I never imagined that returning home from a business trip to find a brightly colored playground on my property would be the beginning of the most insane legal battle of my life. My name is Aaron Zimmerman, and I live in a quiet neighborhood called Meadowbrook Estates in suburban Charlotte, North Carolina. I bought my 2-acre property specifically because it gave me privacy and space, backing up to a small wooded area that I loved waking up to every morning. That Thursday afternoon in late April, I pulled into my driveway after a week-long conference in Denver, exhausted and ready to collapse on my couch. Instead, I stared in absolute disbelief at the massive play structure that now occupied the back corner of my land. The thing was huge. Bright red slides, yellow climbing walls, blue swings, and what looked like a miniature castle tower complete with a rope bridge. Kids were actively playing on it, their parents chatting nearby on benches that definitely were not there when I left. I sat in my truck for a full minute, wondering if I had somehow pulled into the wrong driveway. But no, there was my house, my mailbox, my oak tree with the tire swing I had put up last summer. I got out of my truck slowly, my mind racing through possibilities. Had I somehow agreed to something and forgotten? No, absolutely not. I would never agree to a public playground on my private property. As I walked toward the structure, a woman I recognized as Patricia Henderson, the HOA president, approached me with a smile that looked more like a predator baring its teeth. "Aaron, welcome back," she said, her voice saccharine sweet. Patricia was in her mid-50s, with perfectly styled blonde hair that never moved in the wind, and an outfit that looked like it came straight from a country club catalog. "I see you have noticed our new community playground. Isn't it wonderful?" "Patricia, why is there a playground on my property?" I kept my voice level, though my blood pressure was definitely rising. She waved her hand dismissively. "Oh, don't worry about the technicalities. The HOA board voted on this months ago. We needed a central location for the children, and your lot was perfect. It backs up to the woods, plenty of space, really ideal for community use." "You built a playground on my land without my permission," I said slowly, making sure each word was clear. "That is trespassing, destruction of property, and probably a dozen other things." Patricia's smile tightened. "Now, Aaron, let's not be dramatic. This is for the community. Your HOA fees help support communal spaces, and we determined this was the best use of resources. You will find that according to the bylaws you signed when you purchased your home, the HOA has certain rights regarding property use for community benefit." I had read those bylaws front to back before buying. Nowhere did it say the HOA could just build whatever they wanted on my private land. "Show me exactly where it says you can build on my property without permission." "Well, I don't have the documents with me right now, but I assure you it is all perfectly legal. Our lawyer reviewed everything." She started to turn away. "Now, if you will excuse me, I need to make sure the children are enjoying themselves." I pulled out my phone and took dozens of pictures from every angle. The playground, the kids playing on it, the parents lounging on benches, the mulch that had been spread across what used to be my grass, the entire setup. Then I walked the perimeter, noting that they had also installed a small fence around the area, about 4 feet high with a gate, all on my property. The fence posts had been sunk into concrete. This was not a temporary installation. Back inside my house, I immediately started searching through my files for the HOA documents. I spent 3 hours that evening reading every single word, every clause, every addendum. Nothing. Absolutely nothing gave them the right to build anything on individual lots without written permission from the owner. The bylaws covered common areas, which were specifically defined as the entrance to the neighborhood, the small retention pond, and the strip of grass along the main road. My property was not listed as a common area anywhere. Friday morning, I called a real estate attorney named Marcus Chen, who had helped me with the purchase of my house. After explaining the situation, he asked me to send him photos and all the documentation I had. 2 hours later, he called me back. "Aaron, this is completely illegal," Marcus said, his voice a mixture of disbelief and professional anger. "They have no right whatsoever to build on your private property. This is trespassing, and depending on how you want to proceed, could be criminal trespassing since they have altered your land. You have several options here." "What do you recommend?" I asked. "First, send a certified letter to the HOA board demanding immediate removal of the structure. Give them 7 days. If they refuse or do not comply, we file for an injunction and sue for damages. However, you also have the right to remove it yourself since it is on your property. If I remove it myself, can they sue me? They could try, but they would lose. It is your property. They built without permission. You have every right to remove unauthorized structures from your land. I would document everything extensively, though. Photos, videos, witnesses if possible. Make sure you keep all the materials in case they try to claim you destroyed their property rather than simply removing it from yours. I thanked Marcus and spent the rest of Friday documenting everything and writing up a certified letter to the HOA. In the letter, I stated clearly that the playground was built without my knowledge or permission on my private property, that this violated my property rights, and that they had 7 days from receipt of the letter to remove all structures, equipment, fencing, and materials, and to restore my land to its previous condition. I sent copies to Patricia Henderson, the other board members whose names I found in the HOA directory, and the HOA's management company. Saturday morning, Patricia was at my door at 8 in the morning. I answered with my phone already recording. "Aaron, I received your ridiculous letter," she started, her voice sharp. "I don't know what kind of game you think you are playing, but that playground is staying exactly where it is. The community needs it, and frankly, your selfish attitude is exactly what is wrong with this neighborhood. Patricia, the playground is on my private property. You had no right to build it without my permission. I am giving you 7 days to remove it, or I will take legal action. You cannot sue the HOA. You are part of the HOA. That is like suing yourself." She crossed her arms, clearly thinking she had made some brilliant point. "Actually, I can sue the HOA as an entity, and I can specifically sue board members who knowingly violated my property rights. My attorney has confirmed this is completely illegal." Her face reddened. "We consulted with a lawyer too, and he said this was fine." "Then you should get a better lawyer because this one is going to cost you a lot of money. 7 days, Patricia." I closed the door while she was still sputtering threats about fines and violations. The weekend was relatively quiet, though I noticed several parents giving me dirty looks when they brought their kids to the playground. By Monday, I had received the confirmation that all the certified letters had been delivered and signed for. Tuesday afternoon, I got an email from the HOA management company. It was a generic response saying they had forwarded my concerns to the board and that someone would be in touch. Not exactly promising. Wednesday brought a letter in my mailbox not certified, just a printed page, stating that the HOA board had reviewed my complaint and determined that the playground was properly authorized under Section 7.3 of the bylaws, which gave the board authority to develop and maintain common areas and community amenities. I immediately sent this letter to Marcus, who called me back within an hour, laughing. "They are really reaching," he said. "That section explicitly applies to common areas, which are defined earlier in the document. Your lot is not a common area. They are either being deliberately dishonest or their lawyer is incompetent. Either way, this actually helps us because it shows they were on notice of your objection and refused to correct their illegal action." "So what happens after the 7 days?" I asked. "If they have not removed it, we file. I will draft everything so we are ready to go. In the meantime, you could also remove it yourself if you prefer. Like I said before, it is your property." I thought about it. Filing a lawsuit would take time and money, even though Marcus was confident we would win and could recover attorney's fees. The playground, sitting on my property every day, felt like a personal violation. These people had literally stolen my land for their own use. Thursday morning, day 6 of the 7-day notice, Patricia sent a neighborhood-wide email. I was copied on it along with everyone else in Meadowbrook Estates. The subject line was, "Important Community Update," and the content made my blood boil. "Dear neighbors," it began. "As many of you know, our beautiful new community playground has been a wonderful addition to Meadowbrook Estates. Our children have been enjoying it immensely, and it has brought our community closer together. Unfortunately, one homeowner has decided that his personal preferences are more important than the welfare of our children. Aaron Zimmerman has demanded that we remove the playground, showing a shocking lack of community spirit and concern for our young families. The HOA board is working diligently to resolve this situation, but we wanted you all to be aware of who is trying to take away your children's play space. My phone started ringing almost immediately. The first call was from my neighbor directly to my left, an older man named George who had always been friendly. "Aaron, what the hell's going on?" George asked. "Patricia is saying you were trying to shut down a kid's playground?" "George, they built it on my property without asking me, not on HOA common land, on my actual private property that I own and pay taxes on." There was a pause. "Wait, that is on your lot?" "Yes. My property line extends another 30 feet past where the playground is. They literally trespassed and built it without permission." "Jesus, Aaron, I had no idea. I thought it was on the common area behind your house. That changes things. That is completely not okay." I had similar conversations with 3 other neighbors who called. Some were supportive, but others clearly thought I should just let it go for the sake of the kids. One woman, Jennifer, told me I was being petty and that I should be happy to contribute to the community. When I explained again that they could have asked, could have purchased the land from me, could have built on actual common property, she just said I was making excuses to be difficult. Friday morning, day 7, I woke up early and walked out to the playground. No one was there yet. I took more pictures and video documenting the current state. Then I called Marcus. "They have not made any move to remove it," I told him. "I want to take it down myself." "Are you sure? We can file the injunction today." "I am sure. This is my property, and I'm tired of looking at their illegal structure on it." "Okay. Document everything. Take video of the entire process. Save all the materials. If they want to sue you for the value of the playground, having the materials proves you did not destroy anything, just disassembled it. Also, I would recommend having a witness or 2 present." I called George and explained what I was planning. He agreed to come over and act as a witness. I also called another neighbor, Tom, who was a retired contractor. Tom was immediately interested. "You're going to need help if you want to do this properly," Tom said. "That structure looks like it has some decent materials. I will bring my tools and we can break it down right." By 9 in the morning, I had a small crew assembled, George, Tom, and Tom's son Dylan, who was home from college for the summer. We started with the swings, carefully removing them from their frame. Everything was bolted together, which meant it could be unbolted. I recorded everything, narrating what we were doing and why. We had been working for about an hour when Patricia showed up with 2 other board members I recognized as Linda and Sharon. Both were cut from the same cloth as Patricia, well-dressed women in their 50s who spent most of their time finding problems in the neighborhood. "What do you think you are doing?" Patricia shrieked as she ran toward us. "Removing an unauthorized structure from my private property," I said calmly, still recording. "I gave you 7 days' notice. You refused to remove it, so I am removing it." "You cannot do this. This is community property." "Patricia, this is my land. Look at the survey." I had brought out my property survey and had it staked out that morning. "See these stakes? Those mark my property line. The entire playground is within my boundaries. You built on my land without permission. That makes this illegal." Linda stepped forward. "We will call the police." "Go ahead," Tom said, not even looking up from the bolt he was loosening. "They are going to tell you the same thing. This is private property, and the owner has the right to remove things built without permission." Sharon pulled out her phone, presumably to call the police. While she did that, Patricia stood there recording us on her phone as well, probably thinking she was gathering evidence of something. George just shook his head and continued helping us carefully remove panels from the climbing structure. 2 police officers arrived about 20 minutes later. I recognized one of them, Officer Martinez, who had helped with a break-in investigation on my street the previous year. "Aaron, what's going on here?" Officer Martinez asked. I explained the situation, showed him my property survey, showed him the documentation that I had given the HOA 7 days' notice, and explained that they refused to remove their structure from my land. Officer Martinez looked over everything, then looked at Patricia. "Madam, is this property within his lot boundaries?" Patricia crossed her arms. "The HOA has the right to develop community amenities." "That is not what I asked. Is this structure on his private property?" "Well, technically yes, but we have the authority." "No, madam, you do not. This is private property. If you built something on his land without permission, that is trespassing and potentially criminal. Mr. Zimmerman has every right to remove it." "This is ridiculous," Linda shouted. "There are children who use this playground." "Then you should have built it on HOA common land or gotten written permission from the property owner," the other officer, whose name tag read Johnson, said. "You folks cannot just take someone's property for your own use." Patricia's face had gone from red to almost purple. "We will sue you for destruction of property." Officer Martinez shook his head. "If you do, you will lose. He is not destroying anything, just removing it from his land. I suggest you ladies let him finish and then take this up through proper legal channels if you think you have a case. But I am telling you right now, you do not." The officers left, and Patricia, Linda, and Sharon retreated to the sidewalk, still recording and making phone calls. Over the next several hours, various neighbors came by to watch or comment. Some were supportive, others hostile. One father actually got in my face, saying I was taking away his kids' fun. Tom stepped between us and firmly told the guy to back off. By early afternoon, we had disassembled the entire structure. The materials were actually pretty high quality. Pressure-treated lumber, heavy-duty hardware, commercial-grade swing seats and chains. We stacked everything neatly in my garage and the shed. The plastic slides and climbing panels, all the metal brackets and bolts, the rubber mulch that had been spread around, everything. We even pulled up the fence posts, though some of the concrete footings were too deep to remove without heavy equipment. The area where the playground had been looked rough. The grass was dead, there were holes where the posts had been, and the whole space was compacted dirt and some remaining mulch. It would need serious work to restore, which I documented extensively for the inevitable legal battle. That evening, my phone was blowing up with messages from neighbors. The HOA had sent another email, this one even more inflammatory, calling me various names and saying I had stolen from the community. Several people messaged me directly to say they supported what I had done and thought the HOA had overstepped badly. Others said I was selfish and mean-spirited. Saturday morning, I got a letter from a law firm representing the HOA. It demanded that I immediately return all materials and pay $15,000 for damages. I forwarded it to Marcus, who responded that afternoon. "They are bluffing," Marcus said. "They have no case. Let me respond to their attorney. In the meantime, I have been thinking about your options. You could simply store the materials until this is resolved, or you could do something a bit more interesting." "What do you mean?" "Well, those materials have value. They were placed on your property without permission. Under North Carolina law, you could potentially claim ownership of abandoned property or, alternatively, charge storage fees. But there is another angle. You could offer to sell the materials back to them." I started laughing. "You are kidding." "Not at all. They want the playground materials. They can buy them from you. At fair market value, of course. And you keep the money as partial compensation for their trespass on your land, the damage they caused, and the hassle they have put you through." "Would that actually hold up legally?" "Absolutely. They abandoned property on your land. You gave them notice and opportunity to retrieve it. They refused and instead tried to claim it was legally placed there. You have every right to dispose of the materials as you see fit, including selling them, to anyone, including them." I spent the weekend researching the cost of similar playground equipment. The structure they had built was not cheap. The lumber alone was worth several $1,000s at current prices, and the specialized playground equipment, the commercial swings, the climbing panels, the slides, that stuff was expensive. I put together a detailed inventory with fair market prices for each component. The total came to just over $12,000. Monday morning, I sent a certified letter to the HOA board and their attorney. In it, I stated that I had removed unauthorized structures from my property and had secured the materials. I noted that the materials had been abandoned on my property despite notification, and that I was willing to sell the materials back to the HOA for $12,000, which represented the fair market value of the components. Alternatively, they could forfeit any claim to the materials, and I would dispose of them as I saw fit. They had 10 days to respond. The response came in 3 days. The HOA's attorney sent a letter threatening to sue for conversion of property and demanding immediate return of all materials at no cost. Marcus responded with a detailed letter explaining why they had no legal standing, citing specific North Carolina statutes about property rights, trespass, and abandoned property. He also pointed out that if they chose to sue, we would countersue for the original trespass, the cost of property restoration, attorney's fees, and potentially punitive damages for their continued harassment. While this legal back and forth was happening, life in Meadowbrook Estates became increasingly uncomfortable. Patricia had essentially launched a campaign against me. Every HOA email included some reference to my destruction of community property or my refusal to cooperate with neighbors. I started getting violation notices for ridiculous things. My trash can was supposedly out too long on trash day, even though I had brought it in at the same time I always did. My mailbox was allegedly the wrong color, despite being the same color it had been for 2 years. They claimed my grass was too long, even though I had mowed 3 days earlier. I documented every single violation notice and took time-stamped photos proving they were bogus. Marcus said this was actually helpful because it established a pattern of harassment and retaliation which would support our case. 2 weeks after I had sent the offer to sell the materials, I got a phone call from a number I did not recognize. It was a man who introduced himself as Donald Price, one of the HOA board members I had not met before. "Mr. Zimmerman, I want to apologize," Donald said. "I was out of the country when all of this happened, and I have been catching up on the situation. I voted against the playground project from the beginning because I thought we should build it on the actual common land near the pond, but I was outvoted. I did not realize they had built it on your private property without permission. That is completely wrong." "I appreciate you saying that," I said, genuinely surprised. "I have talked to the other board members, and while Patricia is still convinced she was in the right, several of us agree that the HOA made a mistake. The problem is, the HOA budget does not have $12,000 to buy back the materials. We spent almost that much building it in the first place, plus we have used a lot of our reserve fund on the legal fees from this dispute." "That is not really my problem," I said, though I kept my tone polite. "They built on my land without permission and have been harassing me ever since I objected. I am being more than fair offering to sell the materials back at cost." "I understand. I'm wondering if there is any room for negotiation. What if we paid in installments?" I thought about it. "Let me talk to my attorney and get back to you." Marcus was skeptical. "If they pay in installments, there is a risk they stop paying after a month or two, and then you have to chase them down. But if we structure it right, with a contract that includes consequences for non-payment, it could work. Honestly, Aaron, I think you should just keep the materials and let them sue if they want. We will countersue and you will come out ahead." "I know, but maybe this is a way to end it without months of litigation. If they pay and we are done, I can go back to living in peace." We worked out a proposal, 6 monthly payments of $2,000 each, with a signed agreement that included a confession of judgment clause. If they missed a payment, I could immediately get a judgment against the HOA for the full remaining balance, plus interest and attorney's fees. Additionally, they had to drop all claims against me, remove all the retaliatory violation notices from my record, and agree not to harass or retaliate against me in the future. Donald presented this to the board. According to him, there was a huge fight. Patricia and Sharon voted against it, but Donald and 2 other board members voted in favor. Linda was the tiebreaker, and eventually voted yes, apparently because the HOA's attorney had told them in no uncertain terms that they would lose badly if this went to court. 3 weeks after I had dismantled the playground, I signed an agreement with the Meadowbrook Estates HOA. They would pay me $12,000 over 6 months for the return of the playground materials. In exchange, I would release them from further claims related to the trespass, and they would remove all bogus violations from my record and cease any retaliatory actions. The first payment arrived on time, so did the second, but the third payment, due at the beginning of August, did not show up. I waited an extra week in case it was just delayed, then contacted Marcus. He sent a demand letter, and I got a call from Patricia. "We do not have the money," she said bluntly. "The HOA just had to pay for emergency repairs to the retention pond, and we used what we had budgeted for your payment." "Patricia, that is not my problem. We have a contract. You miss a payment, I get a judgment for the full remaining balance." "That's ridiculous. We just need another month." "No, the contract is very clear. You can come up with the money or I will file for the judgment. You have 3 days." She hung up on me. 3 days later, I filed the necessary paperwork. The HOA did not contest it because the contract included the confession of judgment. I received a judgment for the remaining $8,000 plus accrued interest and attorney's fees, which brought the total to about $9,000. The HOA did not have $9,000 sitting around. What they did have was a reserve fund that was supposed to be for emergency repairs and major maintenance. Donald called me again, sounding tired and frustrated. "Aaron, the board is going to have to tap into the reserves to pay you. This is going to cause a huge problem for the neighborhood, because we need those funds for actual emergencies. Patricia and Sharon are still refusing to take any responsibility for this mess." "Donald, I am sorry the HOA is in this position, but again, none of this is my fault. I did not trespass on anyone's property. I did not build something without permission. I just defended my rights." "I know. I am not blaming you. I'm just giving you a heads up that things are probably going to get worse before they get better." He was right. The HOA paid the judgment in full, draining most of their reserve fund. At the next HOA meeting, which I attended with Marcus as my attorney, there was absolute chaos. Homeowners were furious when they learned that the board had caused this situation and had cost the HOA tens of thousands of dollars in playground construction, legal fees, and the judgment to me. Several homeowners demanded the board's resignation. Patricia, predictably, tried to paint herself as the victim, saying she had only been trying to help the community and that I was the villain who had sued them into bankruptcy. Donald, to his credit, stood up and explained exactly what had happened. How the playground had been built on my private property without permission, how I had given them notice to remove it, and how they had refused and tried to bully me instead. "Patricia, you and the board made an illegal decision," Donald said firmly. "You built on private property without permission. That is not a gray area. That is not a difference of opinion. That is illegal. And instead of admitting the mistake and fixing it, you doubled down and cost this HOA thousands of dollars we did not need to spend." A homeowner named Rachel stood up. "I move that we hold a vote of no confidence in the current board and elect new leadership immediately." The motion passed almost unanimously. Patricia, Sharon, and Linda were removed from the board that night. Donald stayed on because people recognized he had tried to stop this disaster. 3 new board members were elected on the spot, including Rachel and Tom, the contractor who had helped me dismantle the playground. After the meeting, several neighbors came up to apologize to me. Some admitted they had believed Patricia's version of events without getting the full story. Others said they had known I was in the right but had not wanted to get involved in the drama. I appreciated the apologies, though the whole situation had left a bad taste in my mouth. But the story was not quite over. A month later, I received a call from Officer Martinez. "Aaron, I thought you should know that we have opened an investigation into your HOA," he said. "Specifically, Patricia Henderson and how she managed HOA funds." "What do you mean?" "Several homeowners filed complaints alleging that Patricia may have misappropriated HOA funds. When the new board did an audit of the finances, they found some significant discrepancies. It looks like Patricia may have been using HOA money for personal expenses." This was not entirely surprising given how she had operated, but it was still shocking. "How much money are we talking about?" "I cannot give you specifics because it is an ongoing investigation, but it is substantial. Enough to be a felony." Over the next 2 months, the investigation unfolded. It turned out Patricia had been treating the HOA bank account like her personal piggy bank for years. She had used HOA funds to pay for landscaping at her own house, to cover her country club membership, even to pay for a vacation to Hawaii. The total amount was over $40,000. Patricia was arrested in October and charged with multiple counts of embezzlement and fraud. The case made the local news, and suddenly everyone in Charlotte was hearing about the Meadowbrook Estates HOA disaster. Patricia tried to claim that she had authorization to use the funds, that they were reimbursements for HOA expenses she had personally covered, but the paper trail told a different story. She had falsified receipts and invoices to cover her tracks. The trial happened in March of the following year. I was called as a witness to testify about the playground situation and how Patricia had handled it. I explained the timeline, showed the documentation, and described how she had tried to intimidate me and rallied the neighborhood against me rather than admitting the board had made a mistake. The prosecutor used my testimony to establish Patricia's pattern of behavior. She believed the HOA and its resources were hers to use as she saw fit, without accountability or regard for rules and laws. The playground was just one example of her overreach, but the embezzlement showed the full extent of her entitlement. Patricia was convicted on 7 counts of embezzlement and 2 counts of fraud. She was sentenced to 3 years in prison and ordered to pay full restitution to the HOA. Her husband, who apparently had not been involved and was blindsided by everything, filed for divorce immediately after the sentencing. In the aftermath, the Meadowbrook Estates HOA underwent major changes. The new board implemented strict financial controls, including requiring multiple signatures on any expenditure over $500 and mandatory monthly financial reports to all homeowners. They also revised the bylaws to make it explicitly clear that the HOA could not build or modify anything on individual lots without written permission from the property owner. The area where the playground had been on my property took most of the year to properly restore. I had to bring in landscapers to remove all the concrete footings, level the ground, and plant new grass. The HOA's insurance eventually covered some of the restoration costs as part of the settlement of potential claims, but I still put in a lot of my own time and money to get my yard back to the way I wanted it. As for the playground materials, after the HOA made their payments, I returned everything as agreed. The new board decided to build a smaller playground on the actual HOA common land near the retention pond. Tom volunteered to help with the design and construction, making sure it was done properly and legally this time. They used the materials I had saved, which was actually kind of satisfying. The kids got their playground, just in the right location and done the right way. My relationship with my neighbors gradually returned to normal. The few who had really attacked me during the controversy remained distant, but most people moved on. George and I became better friends through the whole ordeal, and Tom and I started having occasional beers on the weekend. Donald stepped down from the board after a year, saying he was tired of the drama and just wanted to live in peace, which I completely understood. I still live in Meadowbrook Estates. My 2-acre property is mine again, peaceful and private like I wanted when I bought it. The whole experience taught me a lot about standing up for yourself, even when it is uncomfortable, and even when people try to make you feel like you are the problem. I had not wanted conflict. I had not been looking for a fight. But when someone violates your rights, sometimes the only option is to fight back, document everything, and trust that the law is on your side. Looking back, I do not regret anything I did. I gave the HOA multiple chances to fix their mistake. They chose to double down and attack me instead. They paid the price for that choice, and Patricia paid an even bigger price for her years of corruption. Some people in the neighborhood still think I should have just let the playground stay, that I made a big deal out of nothing. Those people do not understand that it was never about the playground itself. It was about the principle that you cannot just take what is not yours. You cannot just ignore property rights because you think your cause is more important, and you cannot bully people into giving up their legal rights because standing up for yourself is inconvenient for you. The whole saga, from finding the playground that April afternoon to attending Patricia's trial the following March, was one of the most stressful periods of my life. But it also showed me that I had good people around me. Marcus was an excellent attorney who guided me through the legal complexities. George, Tom, and Dylan stepped up to help me physically dismantle the playground when it would have been easier to stay out of it. Donald had the integrity to admit the board had been wrong and work toward a solution, even when it meant going against Patricia and the others. I learned that HOAs can be wonderful when run by reasonable people who understand their role is to maintain common spaces and enforce reasonable rules for the benefit of everyone. But they can also become little fiefdoms where petty tyrants abuse their tiny bit of power to push around their neighbors. The key is accountability. The key is making sure that HOA boards know they answer to the homeowners and they have to follow the same laws as everyone else. These days, I serve on the HOA Architectural Review Committee. I never thought I would voluntarily get involved in HOA governance, but after everything that happened, I felt like I had a responsibility to help make sure Meadowbrook Estates did not go down that path again. The committee reviews requests for modifications to homes, like adding decks or changing paint colors, and we try to be reasonable and responsive. If someone wants to do something that is not specifically prohibited and is not going to harm anyone else's property values, we generally approve it. It is not complicated. The new playground near the pond is nice. I see kids playing there when I drive past, and it makes me happy that they have a good space. It is exactly where a community playground should be, on community land, built with proper approvals and oversight. Sometimes I wonder if things would have been different if Patricia had just come to me before building the playground, if she had knocked on my door and said, "Aaron, we are thinking about building a playground, and your property has a great spot for it. Would you be willing to sell us that corner of your lot or grant us an easement?" Maybe I would have said yes, maybe I would have said no, but at least I would have had the choice. That is really what the whole thing came down to, choice and respect. Patricia and the old board did not respect my property rights. They did not think they needed my permission. They thought their wants overrode my rights. And when I stood up for myself, they tried to destroy my reputation in the neighborhood and bully me into submission. They failed, and they paid for it. On quiet evenings now, I sit on my back deck looking out at my restored yard and the woods beyond. The oak tree with the tire swing is still there, swaying gently in the breeze. My property is mine again, private and peaceful. I earned that peace the hard way, but it was worth every moment of stress, every dollar spent on legal fees, every uncomfortable conversation with neighbors who thought I was being unreasonable. My advice to anyone facing something similar is simple. Document everything, know your rights, get a good attorney, and do not let anyone bully you into giving up what is legally yours. People will try to make you feel guilty. They will question your motives. They will call you selfish. Stand firm anyway. Property rights matter, contracts matter, the law matters, and sometimes the only way to make people understand that is to enforce your rights, even when it is hard. The lumber from that playground, which I ultimately returned to the HOA after they paid me, was just wood and metal and plastic. But what it represented was much more significant. It represented the principle that you cannot just take what you want without permission, no matter how good your intentions might be. It represented the idea that rules and laws apply to everyone, even HOA boards who think they are above such things. And it represented my refusal to be pushed around on my own property. I got paid $12,000 for materials that were illegally placed on my land. Some people thought that was outrageous. I thought it was fair compensation for the violation of my property rights, the damage to my land, and the months of harassment I endured. The money itself was not the point, though. The point was making it clear that actions have consequences and that you cannot trample on someone's rights without paying a price. In the end, justice was served in multiple ways. I got my property back. The HOA got new, honest leadership. The neighborhood got financial reforms and better governance. And Patricia got exactly what she deserved, a prison sentence and a criminal record. The whole experience could have been avoided if people had just followed the law and treated each other with basic respect. But since they did not, I am glad I stood up for myself and saw it through to the end. Meadowbrook Estates is a better neighborhood now than it was before all this happened. That is not because of the playground, which is nice, but ultimately just a playground. It is better because the homeowners learn they have to hold their elected leaders accountable. It is better because we have systems in place now to prevent abuse of power. It is better because everyone understands that the HOA exists to serve the community, not the other way around. Sometimes I run into people from the neighborhood at the grocery store or at local restaurants. Most interactions are friendly now. The drama has faded into history, just another crazy story about HOA overreach that gets told at dinner parties. Did you hear about the guy whose HOA built a playground on his land without asking? People say, shaking their heads in disbelief. Yeah, I am that guy. And I would do it all again exactly the same way. My property, my rules, their materials, my price. That is how private property rights work in America, and no HOA board, no matter how convinced they are of their own righteousness, gets to change that. I am proud that I stood up for that principle. I am proud that I did not back down when it would have been easier to just let it go. And I am proud that ultimately the law worked the way it is supposed to work, protecting individual rights against collective overreach. The whole experience made me a stronger person and a better advocate for myself. It taught me that conflict, while unpleasant, is sometimes necessary. It taught me the value of documentation and preparation. It taught me that having the law on your side matters, but you still have to be willing to fight to enforce your rights. And it taught me that communities are built on mutual respect, not on some people deciding they can take what they want from others for the supposed greater good. I still get occasional calls from people in other neighborhoods facing similar HOA issues. Word spread about what happened in Meadowbrook Estates, and I have become an informal resource for homeowners dealing with overreaching HOAs. I always give them the same advice. Know your rights, document everything, get a lawyer if necessary, and do not back down if you are in the right. Most HOA disputes never escalate to the level mine did, but the principles are the same. Stand up for yourself, because no one else will. As I write this, it has been over 2 years since I came home to find that playground on my property. 2 years since the beginning of the most intense and stressful several months of my life. Looking back, I can see how each decision I made, from immediately documenting everything to hiring Marcus, to dismantling the playground myself, to negotiating the sale of materials, was the right choice. I can also see how easily it could have gone differently if I had been intimidated into backing down or if I had not had good support from people like Marcus, George, and Tom. The money from selling the playground materials covered most of my legal fees and the cost of restoring my property. I broke even financially, more or less, which is better than many people in legal disputes can say. But the real win was not financial. It was knowing that I stood up for myself, that I protected my property rights, and that I held a corrupt HOA board accountable for their actions. Patricia's conviction was just the icing on the cake, confirmation that I had been right to resist from the beginning. These days, when I look out at that corner of my yard where the playground used to be, I see green grass and peaceful space. I see my property intact and whole. I see the result of standing up for what was right, even when it was difficult. And I feel satisfied knowing that I fought that battle and won, not just for myself, but for the principle that property rights matter and HOAs do not get to ignore the law just because they think they are serving the community. The playground is now where it should have been from the beginning, on common land, properly approved and built with accountability. The kids are happy. The parents are happy. The HOA is better managed and financially sound after recovering from Patricia's embezzlement, and I have my property back, along with my peace of mind. That is what victory looks like. Not perfect, not without cost, but just and right and earned through standing firm when others wanted me to bend. I am Aaron Zimmerman, and I dismantled an illegal playground on my property and sold the lumber back to the HOA that built it without permission. It was the right thing to do, and I would do it again tomorrow if I had to. Property rights matter. The rule of law matters. And standing up for yourself, even when others try to paint you as the villain, matters most of all.